Alrighty, so this is just We the People News. Okay? Not an attorney, not giving legal advice. None whatsoever. Okay, it's just my opinion only. And it's a learning video, y'all. And this video happens to be an attorney. So it's just not me saying these things. Just saying. Alright, I never look straight forward, always look around you. Be able to protect yourself by any means necessary. And this happens to be one of them videos. Okay? And let's start this a little bit so I can show you.
Welcome to another edition.
Alrighty. Writ of warranto. Okay? I'll go in a little bit more details as time goes on. And this is a long video. However, I want you to sit and realize one thing. If you look at my other videos in the past, check out the oath of office. Alright? If they are not taking the correct oath of office, then the writ of warranto should apply. Now, will it do anything? Yeah. We got these people that's not taking the correct oath of office, so they're going to uphold their, what is the word I want to use, right? Their trickery against the people, right? They're saying they have an oath of office, but they're not taking the correct oath of office. They know they're not taking the correct oath of office, except cops, sheriffs, and all them. They're not really bright enough to realize they're not taking the correct oath of office. But attorneys and judges and all that, they know it. All right, your Senate, state representative, your Congress, the federal, they're all not taking the correct oath of office. So if they're not taking the correct oath of office, what legit authority do they even have? Just questions, y'all. Okay? My opinion is zero. And that's the reason why, when you get pulled over by the cops, this, that, here, and there, you're going to challenge the judge, the writ of warranto of the oath of office. Now, if you want to know which oath of office they're not taking, check out my videos, right? A couple of videos of the oath of office, right? They're not doing it, period. Then you put also the Foreign Registration 1938 Act, okay? An anti-bravery statement. They're not taking that. Section 7 tells them they have to do it. All right? They're a foreign agency. They're a corporation. They're foreign. All right? They're not taking that. So again, that's number 2 and 3 right there of writ of warranto, because they're not even lawfully and legally allowed to hold office without just them 3 things by itself. People. Just saying. Attorney's not going to do this. These are only for the people that thinks outside the box and what you guys call represent themselves. Okay? You can't represent yourself if you are yourself, but argument's sake, you guys call it that, so we're going to play along with it. Alright? The only people going to do this is the ones that represent themselves to challenge the courts or any other persons, right? They're a corporation, they're persons. So, there we go. Let's listen to what she has to say about it so we can get a little bit more insight.
Of Florida Appeals Journal, I'm Jennifer Carroll. And this week's question to you is, what do you do when you want to challenge a public office, or you want to challenge a sitting incumbent, and you believe they really don't have a right to that office for a variety of specific legal reasons, or some reason you have to challenge an election? Welcome to the extraordinary writ of quo warranto. Quo warranto, like everything else in the law, it's a Latin term, and it means by what authority.
There we go again. Why are we using Latin languages in the United States, people? Sit and think about it. Okay? But again, I'm just saying that I'm not an attorney, so I'm not giving you legal advice. If you want to hear from an attorney, here you go. I guess. All right, there you go.
So when you're dealing with quo warranto, you're challenging the exercise of some right or privilege, the powers of which are specifically derived from the state. Okay, so state authority. And that's what allows you to use this writ. Now, there are a lot of rules for it, but let me just go through some general ones you want to keep in mind. You personally do not have to have standing as a general rule. You don't have to have personal standing or prove that you have personalized harm in order to bring an action, a petition for quo warranto. That's critical. And general rule is anyone has standing to bring a quo warranto as a general rule. I want to refer you to the Martinez case. That's 545 7th 2nd 1338, Florida 1989. The Wiley case, Wiley v. Scott, 79 7th 3rd 702. That's Florida Supreme Court 2011. And McNamara, that is 648 7th 2nd. I believe that's 165, Florida 2nd DCA 1994. And we'll put that in on our site, and you'll be able to get those. But those are...
All right, let's, from my understanding and my listening, this is Florida thing. So you're probably going to have to look up your own states of cases that may or may not have been done in your own particular states. Okay? But in generally, it's all within the same guidelines, right? All right. We're challenging the legit office, public office, right? Whether it's cops, sheriffs, judges, your prosecutor, all them, right? Who's all supposed to have an oath of office? We're going to challenge that. And if you'll look at my other videos, right? Go to the library, get a copy, have the librarian stamp it. That way you would have shown verifiable proof of public record. Make a copy in the library, give it to the librarian, have her stamp it, that you made that copy from the librarian. That's public librarian, right? Library, right? Put it in your writ of warranto. Alright? You'll check everything else. This is becoming too long, but check that out. But always make sure you want to show such claims, basically.
The main ones that really talk about the elements and what gives you standing, what doesn't, and what types of cases you can bring under quo warranto. Also, Chapter 80, Section 80.01 is the Florida statute governing this extraordinary writ. So, when you bring a challenge, I want you to remember, I want to talk about a couple of exceptions too. Generally, the Florida Attorney General has the power to bring the petitions for the writ of quo warranto. But like I've said, it's not exclusive with the Attorney General. Because you're seeking the enforcement of a public right, if the Attorney General chooses not to do it, an individual can go ahead and do it. Okay. And this is why I say you don't have to show personal harm. You've got to show that you are trying to protect the public and you're exercising this petition and you're exercising this challenge because you are trying to protect rights belonging to our public. All right. Now, you need to know there is an exception. There's a statutory exception that exists for quo warranto. If you're challenging an election or a right to hold office that arises from that election, and generally the person who makes that type of quo warranto challenge under those circumstances, you either have to be the Attorney General or if the AG is not going to bring a suit, you've got to be a person who is claiming right to that office. Okay, that's important. I'm going to refer you to Section 80.01, Florida statutes, and that's going to guide you when that occurs. 4 elements to quo warranto. First, you have a Florida official, government agency, or another recipient of a power or right that is derived from the state of Florida. So you can have an officer in a corporation, you can have a private company that you can bring quo warranto against them if their authority in some respect is being derived from the state. So that, and I think the McNamara case may be an example of that, and there are some others. That's number one. And then that official or officer has exercised that power or right that's derived from the state government, from our state statutes. But such use of that power is or will be legally improper. It's going to be illegal. And therefore, you're going to tell the court, you're asking them, you should exercise its discretion, because it's discretionary, to grant this discretionary writ. Those are your four basic elements. All right. Now, a lot of times you do see quo warranto being used as the remedy to test the right of a person to hold office. And again, powers being derived from the state. Now, quo warranto is generally regarded as the appropriate remedy to determine the title or right to the public office and to oust an incumbent who has unlawfully usurped or intruded into the office or is unlawfully holding it. Okay. In certain cases, quo warranto may be your only remedy, maybe the exclusive remedy in determining the right to hold and exercise a public office. So that's when you're going to want to think about using quo warranto and exercising that right to challenge. Now, you can also use quo warranto, as I was saying, to test the claim of a person to employment as well as an office if that employment amounts to some type of liberty or quasi-official right. And here's an example, State v. Brummer, 426 7th 2nd 532, and that's Florida 1982. In that case, the petitioner used it to oust from office an incumbent who had become personally disqualified to perform the duties of the office because he or she lacks or has lost his or her right to practice a profession or a professional art that has to be practiced in order to fulfill the duties of that office. So that's one example. I think that may have been the public defender involved in that case, but that's one example. Now, keep in mind, too, that when contesting elections, oftentimes, especially these days, you do have special procedures that are outlined in the state constitution or in a statute. And you have that in a lot of jurisdictions. And in some of those situations, depending on the language of the statute, the type of statute, it could preclude the use of quo warranto, or courts may hold that quo warranto is cumulative. But check both to see what would be right for your particular situation, because sometimes the statutory right will be appropriate, and then sometimes it won't be, and you'll have to use quo warranto. And the rationale, for example, is you have quo warranto and election contests. They don't serve the same function because an election contest is brought by or on behalf of an unsuccessful candidate, while quo warranto is brought by or on behalf of the people for the protection of the public. That's a key distinction, and that will help you delineate which is really the right remedy given your particular situation. And you can also have, if you think there's a void election, you can use quo warranto to oust people holding office on the basis of a void election. So you'd want to definitely follow the procedures on that. Now, in the Supreme Court, usually when you're applying for quo warranto with state officers and state agencies, you'll take that up with the Supreme Court, because that's where the Florida Supreme Court has the jurisdiction over those types of quo warranto proceedings. The remaining district courts of appeal in Florida.
Which goes back into the question, right? The Supreme Courts are not even taking the correct oath of office. So you may actually have to do a writ of quo warranto even on your Supreme Courts. Just saying. In your states. And then in your, mine's the 5th Circuit. You may have to do it with the 2nd Circuit, and the 6th Circuit, 10th Circuit, 9th Circuit.
And the circuit courts have authority with respect to issuing writs of quo warranto. And so they'll do really everything else. So they don't have the same limitation that the Florida Supreme Court does. Now, as a general rule, unless there's a compelling reason for invoking the jurisdiction of a higher court, a quo warranto proceeding should be commenced in the circuit court. So this is a little bit different from a lot of our other extraordinary writs. So you've got a limited basis for applying for quo warranto in the Supreme Court. And generally, you're going to want to go to the circuit court to start your petition for quo warranto proceedings. Again, I want to refer you to the Wiley case. That's talking about Florida's Constitution authorizing all but the county courts to issue the writs of quo warranto under certain circumstances. And Wiley also says, general rule, you want to go first to the circuit court and file your quo warranto there. So let's just talk about a few examples of quo warranto. So it kind of gives you an idea of when has it been successfully used. In the Moody case, and it's an older case, really old, 39-7-929, 1905. But just a classic example, you want to test a right or a title to a public office. If you want to test the office holder's qualifications or you want to test the selection process, you can use quo warranto. And that's the Bruce v. Kiesling, 632 7th 2nd 601, Florida 1990.
Which again, that's maybe what you want to challenge, right? Some judges and sheriffs are voted in, right? Well, was they lawfully did everything correctly? Does that sheriff have any jurisdiction or authority over you if you don't have the right oath of office?
You also can use it to challenge a holdover after the term of office has expired. And that state ex rel. Landis v. Thompson, 177-464, 1936. And Martinez, which we cited earlier, that was used to challenge the governor's authority to call a special legislative session. Again, quo warranto. You can also use it to challenge a state agency's power.
Even using quo warranto on your governor, right? He's not signing the correct oath of office as well. Nobody's signing them. Just saying.
That you think is illegal. And there was a challenge to a corporate agency's power to...
That being said, it's not illegal. It's unconstitutional. Federal. And they tell you that they must do this, right? So it may not be illegal, but it's unconstitutional.
Them easements in airspace, for example. That's Irvin v. Jacksonville Expressway Authority, 139 7th 2nd 135, Print Law, 1962. The right of a municipality to either exist or to exercise a franchise. You want to test that, you can bring a petition for warranto. And that's Butterworth, the SB 523 7th 2nd 1278. And that's a second DCA, 1988. Those are good.
If some of y'all beat me at it, please show me, right? Because I don't get pulled over by cops. I haven't had much dealing with cops and all that kind of stuff, or judges. So far, they've been ignoring me. So if you guys want to challenge this and just actually think outside the box and proceed forward on this, I guess leave me a message on one of my videos and let me know how you guys did on it, right? I can honestly tell you, it's going to be hard to do. But if we can get this on record that they've been challenged of this, and other people start challenging these things, just saying, You know, one person, they may let things slide. But another one, they're going to just miss a case. They don't want this on record. So any case you have, they may go ahead and dismiss your case just by writing this. Just saying.
Examples, and I like the Gentry Fetch Company v. Gentry. That's 1067-473. Tested the right or title to an office in a private corporation, which is considered a public office because, again, the corporation derived its powers from the...
Did you catch that? Corporation. Right? Rewind that and listen to that again. People seem to think that, you know, this may be true, but attorney just said they're a corporation.
State. So that's an example of applying quo warranto to private situation. You see it in criminal prosecutions. You have a defendant in criminal prosecution may petition for a writ of quo warranto to challenge the authority of an individual prosecutor assigned by executive order to prosecute the case. Another example of when you can use quo warranto. I think the McNamara is a fascinating case. McNamara v. Kissimmee, River Valley, 648 Southern 2nd 155. That's law 2nd DCA 1994. There was a challenge to the authority of a riparian owner to fence a portion of a navigable lake and spoil island on the theory that any right to do so must be derived from the state. It's a fascinating case. I recommend you look into that if you have something that may be similar. So those are classic examples where quo warranto has issued in Florida. Just remember, you still have some of the standard rules that apply, and remember 9.100 that's used for many other extraordinary writs. You want to follow those rules with your petition. Remember, it's not an appeal. You're going to have to file an appendix with key documents that you want considered, usually part of the record, with your petition. And of course, if there's another remedy that applies, then you're not going to really want to use that. Okay. And again, you still, while you don't have any set time requirements like you do so many writs, time is always of the essence, usually on these type of things, especially with election matters and the right to hold office. So don't forget about Rule 9.100. So there, in a nutshell, about as brief a nutshell as we can do, is the basic law, these are the basic rules on quo warranto and when to apply it. So again, when you have that question, whether it's an election type of case, or you want to challenge somebody in public office, or something in the political process, or in private corporation, as long as the projected action that you think is illegal, you're talking about power derived from the state, then be thinking in terms of quo warranto. That's our edition for today on this particular extraordinary writ. By all means, if you have any questions, let us know. And
all right, we're going to stop there. There you guys go. All right. Never look straight forward. Always look around you. Be able to protect yourself by any means necessary. If they can use these things, so can you. Just saying. These will be the people news. Till next time. Bye.